Hello. On the fourth day of Christmas, my true love gave to me 4 calling birds. Well, I've got a whole flock of them to talk about today because I want to talk about the case of the Crown on the application of the Royal Society for the Protection of Birds versus Natural England, 2019 EWHC 585 admin, a decision of Mrs Justice Lang in March of 2019. And this was a case all about hen harriers and Natural England's decision to licence a research programme to undertake something called brood management, where hen harrier chicks would be taken as eggs from the grouse moors where they would otherwise be, hatched off-site, fed, raised, fledged, and then put back into the wild at a later stage. The idea being to relieve pressure on grouse moors and hopefully, ultimately, change attitudes towards their persecution, which is the biggest problem facing hen harriers despite the high level of legal protection that's given to them. The RSPB didn't like the trial. They thought there were better ways of achieving conservation of the hen harrier, and so they challenged the decision to grant the licence, and they did so on a total of 8 grounds. But in this short video I'm only going to deal with 2 groups of challenges. The first and perhaps main ground of challenge that they had was to allege that the licensing process had been misunderstood and misapplied by Natural England. Section 16 of the Wildlife and Countryside Act 1981 allows Natural England to issue a licence to authorise what would otherwise be criminal offences under Section 1 of the Act, which include the taking of eggs of birds like hen harriers. And a licence can only be granted for one or more of a number of purposes, one of which is, in brief, scientific research, another of which is conserving wild birds. But whichever purpose the licence is sought, the licence can only be granted if Natural England are satisfied that as regards that purpose there is no other satisfactory solution. And the RSPB argued that there were other ways to achieve the conservation of the bird species, and they said that was the purpose of the trial, because that you could look at better enforcement of the criminal law, or you could undertake something called diversionary feeding, where the chicks were fed in their natural habitat but with something other than grouse chicks. This argument was rejected by the High Court because the court found that it rested on a misunderstanding of what Section 16 actually said, because the restriction on granting a licence requires you to think about satisfactory alternatives as regards the statutory purpose. And Natural England had only relied upon the statutory purpose of carrying out scientific research. And so when you're carrying out a trial in relation to brood management, something that isn't brood management wouldn't be a satisfactory alternative when you're wanting to research the effects of a brood management programme. And so that ground, which I think was the fundamental point of the challenge, was rejected. There were also 2 other connected grounds which alleged that there would be an adverse effect on the integrity of the special protection areas which the grouse moors had at their heart. Because, RSPB argued, there would be displacement of hen harriers from the SPA areas, and they pointed to various bits of European case law which said that that amounted to an adverse effect upon the integrity of the SPAs. This argument was also rejected because the High Court said that there would be no permanent displacement of any birds from the SPAs. No adult birds were going to be moved at all. The chicks would be taken as eggs temporarily and then released back into the wild. And if the trial worked well, there would be an overall increase in the number of hen harriers and an improvement to the integrity of the SPAs. And if the trial did not work well, Natural England had made it clear that they had the powers and would in suitable cases use them to stop the trial from going any further. And so those arguments about adverse effects on the integrity rather of the SPAs were rejected. All the other grounds that were pursued were also rejected. I'm not going to deal with them in this short video. Have a look at the decision if you want to understand more about them, but they were all rejected. The RSPB are appealing. They've been given permission to appeal, and it's listed for a hearing in the Court of Appeal in late January next year. So let's see what happens when the Court of Appeal hear the case. That's all I wanted to talk to you about today. Thank you for listening, and I hope you have a peaceful Christmas and a 2021 which is better than 2020 has been. Goodbye.